So I'm joined by Brandon Silver for this week's edition of Construction Question Time. Brandon answers frequently asked questions in the construction sector. Good morning, Brandon.
Morning, Julie. How are you?
I'm good, thank you. Another lovely sunny day, thank goodness.
Yeah, 36 degrees.
Yeah, it's definitely time to be staying in the shade. Right, there's a recently published TCC decision versus Kilhan Construction Limited that seems to be at odds with common practice of the final dates for payment to the provision of VAT invoices. Can you explain what this could mean for the construction sector, please?
Yes, this is a very good question, and it was a case that was published a couple of days ago by the Technology and Construction Court. And it's actually a very important case that could have quite a large impact on the construction industry and quite a big change. So the very good question that I'm going to talk about today. So just in summary, what the actual case is, it's called Rochford Construction Limited versus Kilhan Construction Limited. And what it found was that a final date for payment must be a fixed period of time from the due date under a construction contract. And what it held in particular was that when a final date for payment is dependent on the provision of a VAT invoice, then this provision, this clause in the contract will be deemed to be non-compliant with the Housing Grants Construction and Regeneration Act and will therefore be invalid. It's described as being floating, and because it's not a fixed period of time from the due date, because it's unknown depending on when the VAT invoice will be issued, then it will be deemed to be non-compliant. So what I'm going to talk about in a bit more detail now is what actually the Construction Act provides for in relation to final dates for payment, refer you to the relevant sections of the legislation, explain in a little bit more detail what actually is a final date for payment and what the impact is of this case. So firstly, let's look at the Construction Act. Now, under section 110, it provides that every construction contract shall provide an adequate mechanism for determining what payments become due under the contract and when, i.e. the due date, and should also provide a final date for payment in relation to any sum which becomes due. The parties are, however, free to agree how long the period is to be between the date on which the sum becomes due and the final date for payment. So that's what the Construction Act provides. So what is the final date for payment? So it acts as a long stop date for payment. And what happens is if the paying party, the party that needs to pay the sum of money, does not pay by that final date and does not serve a pay less notice prior to that, then the sum that's been claimed for will be regarded as the notified sum and must be paid by the paying party. If they do not, then the party making the claim for payment can bring an adjudication, and that is known as a smash and grab adjudication. And it's something that we do deal with from time to time. So what happens then if in the contract it does not provide for a final date for payment and therefore does not comply with section 110 of the Act, which I just said has to provide a final date for payment? Well, what happens then is that the scheme for construction contracts will apply, and what it does is it implies provisions into the contract. So what provisions would be implied? Well, it provides that payment would become due 7 days after the date of valuation, so that would be the due date, and then the final date for payment would be 17 days from the date payment becomes due, so 17 days after the due date. So that would be the provisions that would apply if the contract does not comply with section 110 and does not include a final date for payment. So now that I've given that summary, let's actually talk about this case. What this case held was that it does not permit floating final dates for payment. It must be a fixed set period of time, i.e., for example, X amount of days after the due date. If, however, in this case, the final date for payment was dependent on the provision of an invoice, then that is deemed to be floating because it's uncertain when actually the final date for payment would be. And it was held in that in this case, it must be a fixed period of time from the due date. As it was not, the scheme applied, it implied provisions into the contract, namely that the final date for payment would be 17 days from the date the payment becomes due. So Funnily enough, I actually recently was reviewing a contract, and it actually had this clause in there. So I thought it would be useful to actually read out to you the clause. And this is the kind of clause that would potentially, following this case, be deemed to be non-compliant, and therefore the scheme would apply and imply provisions in the contract. So the clause reads as follows. Subject to clause 25.5, which is concerning payless notices, the employer shall pay the contractor the amount certified in each payment certificate, together with the VAT thereon, in accordance with 45 calendar days of the due date. That would be fine, because it's within the due date. However, this is where the stumbling block is. Or, if later, 5 calendar days after the employer receives from the contractor a valid invoice, and such date shall be the final date for payment of such sum. You can see that if the clause stopped halfway through, there would be no problem. It's a fixed date from the due date. However, because it says, or if later, depending on the provision of an invoice, this means that the clause would then be floating and therefore deemed, pursuant to this case, not to be valid and non-compliant. So that just shows you what this case is saying. Now, you asked in the question, well, what is the actual impact of this? And in my opinion, I believe that this will lead to a lot more smash and grab adjudications. I mentioned briefly what that is before, but that's when a payless notice has not been served and the sum therefore has passed the final date for payment and has become the notified sum. So they're claiming the payment of that. And what I believe is that when the scheme applying for 17 days after the due date, it will tend to be the case that this will be a shorter period of time than what the contract would have provided. And in many cases, the party that needs to make payment wouldn't have served the payless notice on time, because they obviously were not aware that the scheme would apply, which is a lot shorter period than the VAT invoice, and therefore the sum becomes notified. So I think a lot more times this is going to lead to parties that are claiming payment seeking smash and grab adjudications and saying, well, you've not issued a payless notice on time, the final date for payment has passed pursuant to the scheme, we are therefore bringing this adjudication. So in conclusion, if you are entering into a contract, ensure that you do not include this clause because of the potential for the scheme to apply. If you've already entered into a contract, then please do note this case and the potential for smash and grab adjudication. So if you're the paying party, then you may have a chance for smash and grab adjudication. Sorry, if you are the paying party, then you need to ensure you've served the payless notice on time. If you're the party claiming payment, then you may have the opportunity for a smash and grab adjudication. Thank you for listening. And if you have any questions in relation to this, my email address is brandonsilver@silverllp.com. Thank you for listening.
Great, thanks for that. I think that will have quite wide-ranging implications, and so we look forward to hearing more on that. Thanks for the explanation, Brandon. Very much appreciated. And,
thanks, Julie.
see you soon.
See you soon.